Okay, I think we are good to go. So good afternoon, folks. Welcome back to Tenant Tuesdays at 2. My name is Kadeem Morris. I'm an attorney here in the housing unit at Community Legal Services of Philadelphia. Tenant Tuesdays at 2 is a weekly tenant-focused program that brings issues that tenants are facing to the forefront, and we have experts from different areas, including the Fair Housing Commission, who will be joining us this week, come and share their expertise about how you can connect with their organizations, receive services, and how best to navigate the COVID-19 period. If you are looking for assistance as a tenant in terms of legal representation or legal advice, you can go to phillytenant.org, which is www.philly, P-H-I-L-L-Y, tenant, T-E-N-A-N-T.org, or you can contact our hotline at 267-443-2500. We do have Spanish translation services that are available. If you're joining us via Zoom, you can click on the interpretation icon at the bottom of your screen, and that will allow you to hear this presentation in Spanish. It will also be available at a later date on YouTube in Spanish. Today, I'm joined by Allison D. Medeiros, the staff attorney with the Fair Housing Commission of Philadelphia. And we're going to talk about the commission today, the services that they provide, and how you as tenants or even landlords, if you may be listening to this presentation, can engage with the commission and what resources they are able to provide to you in advance of full-blown litigation through the court system. So welcome, Allison.
Hi, Kadeem.
How are you?
Thanks for having me. I'm doing well. How are you?
I'm doing good, thank you. So just a few brief updates before we get our conversation started. The municipal court system is still currently closed. The City Council of Philadelphia just passed a piece of legislation that theoretically extends the moratorium or the COVID-19 emergency period as it relates to evictions through August 31st. We're still waiting to see how that bill actually gets implemented and works itself through the system, and we'll probably be able to, at a later date, provide some more concrete advice as to whether or not you will have to engage with court in any way, shape, or form during this time period. But most service providers, including the Fair Housing Commission, are working remotely. So, Allie, how about we get the conversation started with you explaining to us what is the Fair Housing Commission?
Sure. The Fair Housing Commission is a City of Philadelphia commission that's a resource for tenants who are experiencing a lot of different issues. We're currently located, our offices are at 601 Walnut Street, Suite 300 South, Philadelphia, PA, 19103. Our website is www.phila.gov/Fair Housing Commission. Normally, when we're not experiencing a global pandemic, we take walk-ins. Currently, we're working remotely, so how we're taking any questions or complaints is by first the phone number, 215-686-4670. Because we're working remotely, you should leave a voicemail. We've been responding within about 48 hours. We're also accepting complaints by email, and you can email us or any questions at fairhousing.com.phila.gov. Do you want me to just jump into what it is we do?
So if I remember this correctly, the Fair Housing Commission is that building that's across the street from that park. Right,
yeah, we're in the Curtis building. We're right near Washington Square West. It's a very pretty park when we're not, again, experiencing a global pandemic. But we're over in Old City.
And you guys are now working remotely. And as you said, people should call, leave a voice message, and they'll receive a call back within about 24 to 48 hours, depending on, I guess, how busy things are. As we know, that fluctuates day to day. So let's roll right into, what does the Fair Housing Commission do? Like, what can I bring as a tenant? What can I bring to the commission?
So there's basically three types of things we deal with. The first big category is unfair rental practices. So unfair rental practices are under the City of Philadelphia City Code. It's in Chapter 9800 if you'd want to look it up. And it basically gives 3 different categories of things that landlords are not allowed to do. If landlords do any of these things, you're allowed to come to the Fair Housing Commission and file a complaint. The first type of thing that the landlord cannot do is the landlord can't change a condition of your lease if the property is under investigation and has been cited by the Philadelphia Department of License and Inspections. So first I'm going to break it down. So the landlord can't change a condition. So that means he or she cannot terminate it, modify it, or alter it. And so that means, for example, if you have a leaky roof and you call L&I, which is 311 on your phone, and a L&I inspector comes out and violates the landlord, saying that that's not up to code, the landlord can't go around and send you a notice saying that your rent's now raised to pay for fixing the roof. That's
I
most.
think,
go ahead.
just to break that down a little, in terms of license and inspection. So license and an inspection is a city agency that basically enforces the habitability ordinances throughout the city of Philadelphia. So a tenant has the right to go to L&I and say, my property is not habitable, or I've had these conditions that I've tried to get my landlord to repair, and the landlord has not addressed those conditions.
Absolutely.
And if the landlord then sends a tenant a notice saying, okay, get out, or you've got 10 or 15 days to leave, that is a case that the tenant can then call the Fair Housing Commission and say, I'm being wrongfully evicted because I'm trying to have a habitable home. Yes,
exactly. The second type of case we typically deal with is pretty close to what you're describing, where if a tenant exercises a legal right and the landlord comes back and again tries to change your lease because they don't like that you exercise the right. So we know that as retaliation. And those types, so as Kadeem was, as you were saying, you have an absolute right to call L&I. You have a right to form or join a tenants union. You have a right to withhold your rent because your landlord's failing to make repairs. And you have an absolute right to file with us or with another court if you have some issue with your landlord. And your landlord can't turn around and say, okay, fine, get out, or fine, your rent's now $1,000 a month, or turn off your utilities.
So I think and we kind of talk about some of that in the context of an illegal lockout, where you have an affirmative right to stay in your property or get the police involved to prevent your landlord from wrongfully evicting you. But then you also have this separate process through the Fair Housing Commission where they can enforce the unfair rental practice ordinance against your landlord and basically give you some more concrete relief.
Absolutely. Especially with the new bill that was passed, it looks like if you actually are illegally evicted, you're going to be able to take it to the Fair Housing Commission. So that's going to marry very well with our efforts to prevent retaliation. So that's a good thing that's happening.
Okay.
So I'm going to go ahead. Sorry.
Go ahead. No, go ahead.
I'm going to go into the next thing that we typically deal with, and that's good cause. So this is a relatively new concept in Philadelphia. If you are on a month-to-month lease, your landlord has to send you what's called a good cause notice in order to end your lease. They also, if your landlord does send you a good cause notice, you have a right to challenge the reason that they give you for ending your lease. Let me break it down. So first, your lease has to be month to month, which means that it's not for a full year term or any longer. So it renews every month at the end of the month. If your landlord wants to end your lease, he or she has to send you a notice stating the reason, which is good cause, why your lease is being ended at least 30 days prior to the end of the month.
So
go ahead.
That's That's a bit much, I
It's a
think,
lot.
in terms of a mouthful. So this is I think it's an additional protection geared towards preventing a high turnover of housing in Philadelphia for
Absolutely.
vulnerable population. So if you're on a month-to-month lease, your landlord, and it's less, if you're on a month-to-month lease, your landlord has to state a specific reason, and I know you're going to give us what those reasons are, why they're terminating your lease. They can't just freely wake up and say, I'm terminating your lease because I want to. So there's that additional protection built into the law. So what are those reasons?
So the law, which is again 9-800 of City of Philadelphia city ordinances, gives a non-exhaustive, which means it could be these things, but it could also be a whole bunch of other stuff. So the biggest one would be habitual non-payment or late payment of your rent. So if you're behind on your rent, that's an okay, good cause reason for your landlord to end your lease. If you breach your lease, which would be, it has to be something like a material or a major breach. So there's more people at the property than your landlord's agreed you could have there. There's some sort of, maybe you're having a problem keeping the noise down, that sort of thing. If it's constant and major, if it happens frequently and a lot, and it's very serious, they can go ahead and send you a notice and end your lease. Similarly, nuisance activity, so stuff that interferes with the comfort, health, and safety of others around you. If you damage the property, but not normal wear and tear. So if the carpet's stained, that's not going to do it. If a wall, if you knock down a wall, that'll do it. If your landlord gives you access, or I'm sorry, if your landlord requests access to the property and you won't let him in, even after him or her, even after you give, even after they give you at least 24 hours notice, if you just keep refusing to let them in, they can end your lease. If the landlord or their immediate family is going to move into the unit, that's a reason they can give you. Also, if the landlord has to do major renovations that require you to leave. There's more nuances to that in the law. They have to give you notice and you have to have certain options to come back after they're done. Other ones we see are if the landlord is going to sell the property, that sometimes is an issue, is a reason. But basically it has to be a good, non-discriminatory reason for why they need the property back.
So those are, as you said, a non-exhaustive list of options. And we have our first question, which is on this exact issue. So I will let you answer it. The question is, does the good cause ordinance apply to situations where you may have been living in a property on a year's lease and the renewal terms are this becomes a month-to-month lease? From my perspective, it's a yes, but I'm happy to hear what your thoughts are.
Yeah, so in Philly, you'll hear different people argue different depending on what they would like to further. But the Fair Housing Commission's position is that if you were on a year and you've lapsed to a month-to-month, you now absolutely fall within the range of the good cause statute.
So that's good to know, because I think there are people who enter on yearly leases and it automatically renews, or even a 6-month lease, or what I think is happening more frequently is built-in ownership is changing. And when your lease runs out, there's just no renewal. So you're presumed to be on a month-to-month lease at that point, and you get whatever notice is provided by statute. I think we have a hand raised. If you could put your question in the chat box, that would be great. Or we got 2 hands raised. If you guys could place your questions in the chat box, that'll be great. So Ali, as we kind of move through this, I kind of want to pause and see, what does it look like when someone attempts to interact with the Fair Housing Commission? Is there a form that they fill out? What does it look like?
So right now with COVID, what it would look like is you would call or you would email the Fair Housing Commission, who will call you back or email you back and give you access to our intake questionnaire. The intake questionnaire has a lot of questions about all these different types of actions you could file and different questions. Then it's renewed by an intake coordinator. who then drafts a complaint for you if you fall within our jurisdiction. Some cases don't fall within our jurisdiction. We really only deal with issues under the Fair Housing Ordinance. And we also can't deal with a case if it was previously filed in a different court. So given if we have jurisdiction, we'll go ahead and draft a complaint. You'll go through the complaint. We'll make sure everyone is happy with it. It will be served on your landlord, and you'll be given both a case manager and a hearing panel date. In the meantime, your case manager will reach out to both parties and they'll go ahead and try and mediate. They'll see if there's not a way to get those L&I violations closed. There's not a way to get the landlord to agree to renew or some sort of amicable solution. And then if that doesn't work, you go in front of our 4 to 5 person panel, and it's like a court case but light. We're very open with letting people talk and have each side say what they want. And then the commission makes a determination of how to solve the issue or who's correct in the issue, and they do a final order. The final order is binding. You can appeal it, but it has to be honored if not appealed by municipal court or any other eviction court that you go to.
So I think the big takeaways that I'm thinking about from what you said from a client perspective is that you don't have to feel the pressure to have written up your complaint before you contact the commission. The commission is able to assist you through that process, and you're appointed sort of like an advocate who will try to help you and your landlord mediate or resolve the situation, hopefully before it goes to a panel. And then there's a panel at which point you don't have to expect the formal rules of evidence that you might anticipate in a court. No. People are able to freely share information in hopes of coming to a resolution. Yes. We've got one more question on the applicability of the good cause ordinance. And this, I think this is, well, it's 2 questions. It's, does the good cause ordinance apply and what to do in this instance? So does the good cause ordinance apply if you're on a year's lease and your lease is just up? Is that protection applicable?
No, unfortunately not in Philadelphia as the statute is currently written. It's very specific to just month-to-month leases. So if you're in a year lease and your landlord sends you a notice without any explanation, they're not necessarily required to give you any explanation. They do have to, it's the same federal protections that you would have, though. They cannot renew your lease for discrimination if you're in a protected class.
Okay.
What you would do in that situation, even if you're not under the good cause statute, you're still under the other 2 areas I talked about. So if you should check to see if your landlord has any open L&I violations. If there are repair issues in the property that you've reported, you should call L&I, and you should examine whether or not what they're doing is retaliation for anything you might have done. So if I say, I joined a tenants union last month and we've been asking for some changes to the common areas in the apartment, and all of a sudden the landlord just sends me a notice, that's enough for you to come talk to the Fair Housing Commission so we can delve deeper into that and make sure they're still not violating the Fair Housing Ordinance.
Okay. So we're just a reminder to folks, interpretation services are available, and you can just click on the link at the bottom of your screen. So there is a question in the Q&A box that I want to get to. It says that someone's landlord sent them a non-renewal notice for their lease. Well, sent them a rent increase request effective July 1st of 2020. And the last time they signed the lease would have expired in give me one quick second. I'm just trying to fix something on my end. The last time they signed a lease would have been in 2019.
Okay, I'm pulling up my ordinance for rent increases. Okay, so your landlord, the last time they signed a lease was in 2019.
Yes.
Was it for a year?
It looks like it was for a year.
Okay, so it would have been up sometime in 2020.
Theoretically, it should have been up in 2020.
Okay, so if they want to give, I can take an email afterwards. If you want to give them my email address, Kadeem, I'm happy to go through it. But basically, your landlord for a year lease under the Fair Housing Ordinance, they have to give you 60 days written mailed notice that they're
Tiene que
going
dar notificación ahora
to increase
que
the rent.
van a aumentar la renta.
So
Así
if
es
the
que
rent was up at the
si la
end of August,
renta no, si fue pagado a la final de agosto,
they would have had to give
hubieran tenido
notice
que
at the beginning
dar
of June.
notificación al comienzo de junio.
If your lease is month to month
Si el arrendamiento es de mes a mes
or less than a year, they would have had to give you 30 days notice. So beginning of July for them to increase your rent.
Okay, so I just want to pause. We had a little technical difficulty right there. You might have heard Spanish on this side. So we've got it sorted out. So we're gonna redo it. The question was if your landlord sent you a new notice for effective July 1st, seeking a rent increase, and the last time you signed the lease was in 2018 for a year,
Okay.
Is that rent increase proper? And can you get help through the Fair Housing Commission? And then there's also the caveat of the landlord not having a renter's license. So I think this person should definitely call the Fair Housing Commission on this specific issue, but just in terms of if you want to re-give the advice on lease renewals, that'll be great.
Sure. So there is a provision of the Fair Housing Ordinance that gives specific things landlord has to do if he or she's going to increase the rent. So if you're on a year lease, the landlord has to give you 60 days notice prior to the rent increase. So for example, if your year lease was up in August, so the effective increase would be for September 1st, the landlord would have had to tell you about the increase by at least June 1st. Okay. For month-to-month leases, it's 30 days. So same scenario, your lease is up end of August and your rent increase starts on September 1st. You would have had to know by July 1st, or I'm sorry, August 1st. I think am I off by a month? I think I might be off by a month. It has to be 30 days notice from the effective date. So it'd be August 1st and then July 1st. I'm correct, not June. Sorry.
No, that's perfectly fine.
Spanish threw
So, yeah, it's hard to do months in your mind, and I consider that math, so I understand the struggle. So I think the next area of people that are protected or of cases that can come before the Fair Housing Commission is victims of domestic violence. How does that protection work?
So there's two ways in which it works. First, if you're a victim of domestic violence or sexual assault, your landlord can't modify, alter, or end your lease because of an instance of sexual assault or violence, and they can't, or because they know you are a victim of those things. So that cannot be the reason they give you. They can't end your lease for that reason. The second thing is if you're experiencing domestic violence or sexual assault, you can terminate your lease, even if you're in the middle of it, without a penalty. And this gets a little complicated, so I'm going to go very slow. First, you have to request to terminate it in writing. Second, when you request to terminate, it has to be no more than 90 days after the incident of assault or violence, or the issuance, or when you get a protection from abuse order. A protection from abuse order is a criminal order ordering somebody to stay away. It's a restraining order, but in Philly we call it a protection from abuse, or a PFA. So that means if I've got my PFA, if I got my restraining order today, I have to let my landlord know I want to end my lease within 3 months from today. So I can't do it next year. I have to do it pretty quickly afterwards. And I have to do it at least 30 days before I know I'm going to move out. So if I plan on moving at the end of July, I have to let the landlord know on or before July 1st why I'm moving out and that I need to exercise this right. And then I have to leave on the date I say I'm going to leave. So I have to be out at the end of July, and I have to provide my landlord with documentation of the abuse or the violence. And that sounds invasive, but it can be less invasive. It can be just a copy of the restraining order. Or it can be just a simple note from a doctor saying I was treated for an issue with these things. So go ahead.
That brings me to a question that I have in terms of the ability to enforce the protection from abuse orders, or the protection built into this bill language. Do you have to have a PFA from the court for you to get this protection?
No, you don't. You could have just had an incident that occurred in your house, and because of that, or the person's coming to your house and you need to leave. That's enough, as long as you have documentation. It can be a police report. It can be a very simple, non-invasive doctor's note. Like I explained, it doesn't have to be, anything too private.
Okay, I think that's a very important protection to
I do too.
know. So let's talk about, we've kind of talked about the process by which people file a complaint at the Fair Housing Commission. Is there any documents that a tenant would need? Like we had that question about, my landlord doesn't have a renter's license, is trying to increase my rent. Theoretically, if that was a complaint that someone wanted to bring to the commission, what sort of documentation would that person need to have with them or present to the commission?
Sure. So first, because we're in the middle of COVID, we're requiring a lot less documentation than we would normally need. So we're actually taking cases on just the questionnaire. But if you want to be like ahead of the game, we want a copy of your lease. If you don't have a lease, that's fine. If it's just oral, we take oral leases too. If you have your rent in an escrow account, or not even an escrow account, if you're holding your rent because your landlord's failing to repair, we just need proof you have the money set aside. So it can be in your checking account, it can be in your savings account. We just have to know that you are withholding it and you're not making the complaint just because you cannot pay. Then anything between you and your landlord in terms of written documentation, we will take. So pictures of the issue, text messages between you and your landlord, and of course, like the notice of termination or your rent increase notice, like that question we had earlier. We would want a copy of that to make sure they did everything they need to do. If you file with L&I, they give you a case number. We need to know the case number. That way we can look up what's going on with those violations.
Okay, so that sounds good. It sounds like the information that's needed is just the information that people will have handy, their leases, proof of escrow if they have a bank account, or if they just have like cash being withheld. So my question on the L&I part of it, because I know we're in the midst of a pandemic and a lot of things are being slowed down. Does an individual have to wait until after they've called L&I and had an inspection, or is it the moment that they contact the agency and get what I hope is a case number, they can then bring that to the commission?
We've been taking them with less. So if it's been going on for a while, the issue, the repair issue, if it's really affecting your ability to live in the house, and you just called L&I and they told you because of the pandemic it's going to be weeks, we'll take that case, or we'll definitely review that case. But we've been taking cases like that. You don't necessarily need to have a violation if the physical issue is serious and it's been going on for a while.
Okay. So that brings me, I think, to like a really important point, or maybe where we should have started the conversation. What does a landlord in Philadelphia need to have or present to a tenant to be able to rent them a property? Because the commission is enforcing all of these rules and regulations, but it would be great to know, like, what should I expect as a tenant when I go to rent a property?
Sure. So the two big ones are a renter's license and a certificate of rental suitability. I'm going to start with the license. I believe they renew on a yearly basis. Every residential renter in Philadelphia needs to have a renter's license. It means that they are settled on their tax debts with the city and that the property is up to code, no open L&I violations. They don't necessarily need to give you a copy of that when they rent to you, but they have to have one active with the city. If they don't, they can't collect rent. So if I owed the last 2 months of rent and I go and I pull up, you can search on L&I's website, and I see they have no renter's license, I don't owe them those 2 months. Similarly, once you have a renter's license, the landlord has to go get what's called the certificate of rental suitability. The certificate of rental suitability is supposed to be given to you at the beginning of your lease, but once they give it to you, from that point forward, they can collect rent. It does need to be handed to you. It needs to be signed by the landlord. And it needs to be not expired. There's a date on it, and it has to be given to you between the two dates. Along with that cert, they have to hand you something called the Partners for Good Housing Handbook. This is a printable PDF on L&I's website. It's a little booklet. It's got a nice picture of a family on the front. They have to hand it to you with your CRS. Until they do those things, they can't collect rent from you. Those are the two big ones.
So that's real important. And I don't know if the ordinance actually addresses this, but we have a question in our chat that's, can a landlord request a copy of someone's social security card when they are trying to become a renter? I don't know that that's clearly spelled out anywhere, but is that something that the commission could?
It's not in my fair housing ordinance. However, the commission we have a sister commission, the Philadelphia Commission on the Philadelphia Human Relations Commission. If you send it to me, I can send it to them. It might be a discrimination thing, but I'm not sure off the top of my head whether or not they can ask for that. But they
Okay.
deal with our rental applications. I deal with
I would
once you're in.
say to the person who asked that question, we did put the Fair Housing Commission's contact information in the chat. So if you would forward that, you can either call them and leave a voicemail, the number's in the chat box, or you can reach out to them via email, Fair Housing. Let me make sure I get this right. Fair Housing COM @phila.gov.
Yep.
Also, if you Google Fair Housing Commission Philadelphia, the email address and ability to file a complaint should come up. You can send that to them, and then they will forward that to their sister organization, the Philadelphia Commission on Human Relations, I think, and they will deal with it from there. Allison, someone's asking for your personal work email. I'm not sure the parameters around that, so if you just want them to go through the commission, that's fine.
Sure, you're totally fine to email me at my personal work email. Let me put it in the chat because my last name's kind of a mess.
Okay.
Again, give me a 48-hour turnaround. We're swamped.
So, accessibility issues. What does accessibility look like with the Fair Housing Commission? I know we usually think of language access, we think about disability access, we think about all, and I know it's a heightened bar because you are a city and state agency theoretically, so you're required to provide all these services. So what does that look like for maybe someone who doesn't speak English or someone who does not have access to technology? How does that work?
Okay, so I'm going to do it in the context of what we look like during COVID. When you call our office and you are a Spanish speaker and you want to file a complaint, we have most of our intake coordinators speak Spanish. So you just tell whoever takes the call or leave on your message that you're a Spanish speaker, and we'll make sure somebody who speaks Spanish calls you back. That way things are easier. For any other language, if you just mention the language, we can get what's called a language line interpreter on the phone. And they have every language you can think of, and they can get somebody pretty quickly. If for hearings, we can also do a language line interpreter on the phone as well. So if you don't speak a different language, or if you speak a different language, or if you speak English just fine, but you're a little worried about the context of getting your point across exactly right, we're happy to give you a translator. Ask for a translator. We do it all the time. If you don't have access to the internet, we are totally able to take a phone call and mail you our intake questionnaire, accept it back, and then mail it out again for a signature. We're working on having hearings in the near future where we can have people present in a larger space with COVID precautions if you don't have the internet. If not, we're able to, if you do have the internet, we're going to be doing hearings remotely through Zoom like this. Similarly, our building is handicap accessible. We have elevators. We're not encouraging anybody to go there. We can do everything by the phone.
So that's great to know that efforts are being made to accommodate individuals. And it's great to know that the mail service still exists so that people can send things back and forth and be on the lookout for package. If you contact the commission and they send you something, you should be willing to send it back within a timely fashion. So as we begin to wrap up, I like to go over high points of a conversation. The important things that I've heard so far is that the Fair Housing Commission has advocates available to help you with the complaint process and guide you through their processes. And they are accepting complaints through the online portal and by calling in on their phone line and leaving a voice message and responding within 24 to 48 hours, depending on availability. And they are accommodations both based on language access and disabilities, or just inability to engage with the internet as a platform, because not everyone has service to the internet in this time. So Ali, I'll invite you to bring or highlight anything that you think is important for people to know about the commission, or just what's the best way to engage during COVID.
Sure. So when in doubt, give us a call or an email. Part of our job is also to make sure people understand their rights. So if you're not sure if we can help, call or email, and we'll do what we can, or point you to the person who can help. And also, because the courts are down right now, it's essential that you go ahead and file a complaint as soon as possible. Like I said earlier, if your landlord is already filed against you in either the municipal court or the court of common pleas, we can't help. So go ahead, reach out, and we'll do everything we can to at least get you to the person who can help. Yeah, that's pretty much what I always say. Like, you'd be surprised what does fall under, because there are so many different situations when you're dealing with a relationship like landlords and tenants. So if you contact us, we're happy to tell you where the right place is if you're not sure.
And I would also encourage anyone who might think that they're on a month-to-month lease or not sure what their lease terms are, as we are in the midst of this pandemic where a lot of other services like the courts may be temporarily closed. The Fair Housing Commission is one of those places that you can go and attempt to mediate and resolve things with your landlords amicably without the need for an eviction court filing. So I encourage people to reach out to them. As we said, they are available by phone at 215-686-4670, or they accept complaints via email also at fairhousingcom, COMM, @phila.gov. Reach out to the commission if you have a question, and if they can't help you, they will direct you to the best service point. If you are a tenant and you're looking for legal representation or maybe legal advice on an issue, you can feel free to contact the Philly Tenants Hotline. It is 267-443-2500. Again, 267-443-2500. We do have a hand raised. I encourage you, if you can, to put your question in the chat box. I will wait. It seems like the question is in the chat. So I'm going to place the contact info and website for the Philly Tenant Hotline and phillytenant.org in the chat box for individuals who would like to get that information. So Tenant Tuesdays at 2 is a weekly presentation of the Philadelphia Eviction Prevention Project, which is a project collaboratively done between the City of Philadelphia and the Mayor's Office and different legal services providers throughout the City of Philadelphia, including CLS Senior Law, Legal Clinic for the Disabled, and Philadelphia VIP, which is an attorney referral service. So if you are having questions or if you need legal representation, feel free to give the Philadelphia Eviction Prevention Project a call, and we will happily assist you or direct you to the right party who can assist you. And as we like to say, join us next week for a new presentation. We're not sure who our guests will be yet, but we will likely be talking about things as they continue to change in the city of Philadelphia and protections continue to be put in place for vulnerable populations. All of our contact info is in the chat box, and if you are in need of some specific information, we will also be placing that info on Facebook. The video will be available at a later date on YouTube for you to watch, and you can reach out to us. There's lots of information on the web, phillytenant.org or CLS Philadelphia. Both of those are great resources, and the Fair Housing Commission is up, running, and available to assist you guys with any issues that you have. So Allison, thank you for joining us today.
Thanks for having me. Thanks.
And we encourage you to come back if anything changes in your world. And that's about it for today, folks.
Bye.